Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5173. Pauline Newman, Honorable Circuit Judge, Appellant, versus Kimberly A. Moore, Honorable, in her official capacities as Chief Judge of the United States Court of Appeals for the Federal Circuit, Chair of the Judicial Council of the Federal Circuit, and Chair of the Special Committee of the Judicial Council of the Federal Circuit et al. Mr. Dolin for the Appellant, Ms. Patterson for the Appellee.
Morning, Counsel.
Good morning, Your Honors, and may it please the Court. For over 2 years, and as a result of defendant's actions, Judge Newman, a duly appointed federal judge, has been unable to exercise any functions or powers of her office which she holds. She has heard no cases at panel or en banc level. She has written no opinions, has ruled on no motions, voted on no petitions, seen no briefs or pre-publications opinions. This state of affairs constitutes a practical removal from office, something that the Constitution and the Disability Act both prohibit. And there are 3 separate reasons why defendants' actions are unlawful. Defendants have functionally effected unconstitutional removal from office in violation of Article 3 and Section 354A3. Second, defendants have exceeded powers granted by the Disability Act, which, to the extent is constitutional at all, does not authorize seriatim removal. In fact, Section 354A2A Roman 1 speaks only of temporary removal on temporary basis for time certain. And third, these entire proceedings violate basic norms of due process, which at a minimum require a neutral adjudicator in the first instance. I want to begin by emphasizing that ruling for the defendants undermines the independence of every holder of judicial office. If defendants are correct that a temporary suspension from all judicial functions is constitutionally permissible, then it would follow that any judge can be completely debarred from exercising judicial functions, and that such debarment would not be constitutionally problematic so long as the judge continues to receive his or her salary. And it would not be constitutionally problematic whether it's done by fellow judges or another branch. And that simply cannot be correct.
So Counsel, your constitutional arguments are forceful and raise a lot of novel and difficult questions. But as you know, as a panel, we're bound by our decision in McBride, and which on its face, at least, would seem to entirely foreclose your as-applied and statutory challenges. So you've offered us in the briefs a few ways around McBride, and I'm curious which of those you think is the strongest.
I think two-part answer to that question, Judge Garcia. First, I think we have facial challenge to the extent if the statute is construed to mean that it allows suspension of a judge for any period of time from all judicial functions, it's unconstitutional on its face. Of course, through a doctrine of constitutional avoidance, the statute can be construed more narrowly. That's a facial challenge, and that is not explicitly precluded by McBride. Second, I think McBride, on its own terms, even leaving aside the subsequent history, on its own terms, accepts this case. Footnote 5 in McBride explicitly reserves the question of what happens when a suspension of sufficient length affects an effective removal.
You say, Mr. Dolan, that there's a facial challenge so long, and that your facial challenge succeeds if it allows effective removal. But that's not my understanding of how the standard we use in a facial challenge. Are there any constitutional applications of the statute? And the statute isn't limited to practical removals from duty. It has all kinds of lesser effects that I thought your brief was acknowledging were
absolutely
authorized. And
absolutely. We don't challenge, for example, the idea that Judicial Council can impose reprimands. We don't challenge the idea Judicial Council can collect information and certify a judge for impeachment for Judicial Conference and then to the House of Representatives. We don't challenge even the idea that Judicial Council could say that, look, a particular judge had a particularly untoward experience with a particular group of lawyers and therefore should not interact with those lawyers in a courtroom. So absolutely.
What about a backlog? I mean, I know there's been statutory action since Chandler, but the court in Chandler said that it was not unconstitutional for the Judicial Council to pause new assignments to a judge in order to allow management and catching up with the backlog?
Yes, Judge Pillard. So again, two-part answer to that question. First, generally backlog is not dealt with under this act. So this is dealt with under a different statute.
But the question about
right.
constitutionality of Judicial
But-
Council actions vis-à-vis a judge's workload.
Absolutely. And I think the fundamental difference there is when a judge has a backlog, that means he's still exercising judicial functions. The office, when a federal judge, an Article III judge is appointed, he has two separate protections. One, there's a salary protection, which Judge Newman has not been deprived of. And two, the judge gets to hold office during good behavior. Holding office must mean something. And that must mean, given the precedent, that the judge gets to judicially decide questions submitted. And so if a judge has a backlog, by definition means that that judge still has questions before him or her, deciding those in a judicial manner.
I fear that I interrupted you in answering.
Yes, I was gonna get
Judge
back-
Garcia's question about which of the ways of distinguishing McBride you think is the most.
Right. So I was going to get back to.
Can I follow up on the
Sure.
facial challenge, and
Yes.
then we'll get to the ways around McBride. So I have a similar question just about how facial challenge work, because the appellee is going to say, you're asking us to hold the provision authorizing temporary, time-certain assignments, case suspensions, facially unconstitutional. And that the way that analysis works is that if there are a substantial number of constitutional applications of that provision, putting aside what happened in this case, then your facial challenge fails. And what is wrong about that?
So
approach?
I respectfully, Your Honor, I disagree. I think the way to think about our facial challenge is that first you have to figure out what the statutory provision means. And if it means that it allows wholesale suspension of all judicial functions, then it's unconstitutional. If it means something else, then you're right, our facial challenge fails. And then the question is a judicial council's actions fit into that something else framework?
And so this is my next question, which is that argument that if it reaches this far, then it is facially unconstitutional. That sounds a lot like an overbreadth argument, which we in the Supreme Court have only applied in the First Amendment context, not a normal facial challenge, which again, we can take as given that there are many unconstitutional applications, but if there's a substantial number of legitimate ones, a facial challenge fails.
So I respectfully disagree. I don't think it's an overbreadth argument. I think it's just a statutory construction argument. The statute means either A or B. And if it means A, then what the council is doing is ultra vires. And if it means B, meaning that it allows authorized wholesale suspension or removal by practical effects, then it's unconstitutional. So you're right. The court can absolutely avoid the constitutional problem, but in order to get there, you'd have to construe the statute more narrowly. And the upshot is that under either scenario, appellants prevail.
I don't think that's exactly consistent with our precedent or the Supreme Court's precedent on overbreadth. On facial challenges. If there are a substantial number of constitutional applications, then there's not a facial constitutional problem. So we don't go to the step of interpreting it narrowly to avoid the problem. So you're jumping to the narrowing construction, I think, based on an assumption that you've met a factor that I'm not sure I see you having met. The notion that, I think you said that if the statute is unconstitutional because it allows, as one subset of its applications, that's my addition, but because it allows a full-on suspension of duties. And I don't think that's enough to render it facially unconstitutional, and therefore we don't get to the step of being concerned about a narrowing construction.
Well, so I think that
It's an
ultimately,
as-applied
right.
problem.
No, I don't think it's quite correct. I think it's still the first step has to be, what does the statute actually allow? Right. And so you're right. If the court concludes that the statute allows only some sort of temporary suspension when a judge still has, as in a backlog situation, still has judicial duties to accomplish, then you're right. We don't need to get to either as applied or facial challenge. We're done. But of course, that's not what's happening to Judge Newman. If a statute allows more, right, then it's a problem. Then it's a facial problem because the statute. I think that the way the statutory challenge, the way that facial challenges work, is that if whether or not to decision is constitutional rests with an administrative agency, which is what Judicial Council is, and it's purely their discretion, then the statute authorizes them to do something that it cannot do, and it's on its face unconstitutional. So the mere fact that they could behave constitutionally doesn't mean actually the statute is on its face constitutional. That was my speech. But Judge Garcia, to get back to your, so first, as I mentioned, footnote 5 of McBride, on its face, recognizes that there may be actions by Judicial Council that go so far beyond what either the statute or the Constitution authorizes that this court will not stay its hand. This court will have jurisdiction to decide. Second, post McBride, there's two cases actually coming out of the Federal Circuit, Koza v. Lee and SAS versus Iancu, where the Supreme Court explicitly says on a almost identical language that has jurisdiction stripping provision. In that case, in a context of a patent act, Supreme Court explicitly says that jurisdiction stripping provisions only apply when the agency actually acts within the bounds provided by the statute. When the agency goes beyond what the statute authorizes, then the jurisdiction provisions have no effect because you have to be read in context of the whole statute. So this is our statutory argument. It's not so much that we argue that, look, a 6-month suspension would have been okay, but Judge Newman was treated unfairly because she got a year plus. That would be beyond this court's jurisdiction. What we are arguing is that the statute, to the extent it's constitutional, authorizes a temporary suspension for time certain. A renewal, by definition, is not time certain. So this goes beyond what the statute authorizes. Just like in a patent act, when the court said Federal Circuit cannot review director's decision whether or not to institute inter partes review, but if the director chooses to kind of do half institution and half non-institution, because that's not what statute authorizes, the courts can review that. So I think those are our two strongest arguments. Footnote 5 and the fact that whether or not an agency acting ultra vires is for the court.
So if this provision, as you're arguing, doesn't bar our review of a challenge that the council acted in excess of its statutory authority, what does it bar?
It certainly bars seriatim suspensions.
What does the judicial review preclusion
Oh,
prohibit us
oh,
from
okay.
considering?
So for
Because
example,
it's common,
right.
you know.
So for example, if Judge Newman were to come to this court and said, you know, in prior cases, judicial councils of other circuits suspended judges for 6 months, and here I am being suspended for a year, and that's inconsistent, and everybody should be treated the same, that would be barred. If Judge Newman said, look, I am, the court precluded me from hearing.
I'm confused about that point because you spend a lot of time in your brief saying no one has been treated as severely as Judge Newman. But then you
Correct.
just said if her argument was that she was being treated worse than other people, we couldn't hear that.
That's true. I think the point that we made in our
So we
brief.
can't consider your argument that she's been treated worse than any other judge.
No, I don't think that's.
You just said.
Well, no, you can't.
Disparate
Right,
treatment
no.
isn't something we could consider.
You're right. You shouldn't get her relief merely on the basis of disparate treatment. The reason we pointed out that nobody has been treated as poorly as Judge Newman is to show the court that no judicial council previously, Federal Circuit, this court, or any other judicial council has ever viewed its powers to fully remove judicial functions from a judge and do it on a seriatim repetitive basis. So it's not that she's treated more poorly. It's just to illustrate how everyone understood this, everybody understood the statute
But
to
an
mean.
equal protection claim could not be heard.
Yeah, we have not brought an equal protection.
No, you were given an
Right.
example and you just said disparate treatment can't be brought. Equal
Right.
protection cannot be heard, but due process can?
I think so, because due process requires the process be fair itself, not that necessarily the equal protection is.
So a constitutional claim couldn't be brought. That's confusing.
I think the constitutional claim, I think it would be just very hard to bring because each case is somewhat different, and it's the Congress could decide that these intra-court disputes are best settled in the court so long as it doesn't transgress on the constitutional powers of a duly appointed judge.
Are you making that distinction because you think McBride requires it?
I think McBride does require it. I also think that, the 357C, has to mean something. So, the jurisdiction stripping provision. So,
And you see a due process claim as inherently, I mean, you said previously, and I didn't see this as exactly how you argued in your brief, but that you were in defending what you describe as a facial challenge from our understanding of Solerno. You said that in every case, the Judicial Council has discretion, and then in characterizing a due process claim as sort of a facial claim, are you saying that there is in every instance of the Judicial Council's assessment of a judge's conduct and meeting out of a potential limitation or guidance or discipline, that in every case there's something wrong with what the Judicial Council does?
No. I think our claim is much more narrow than that. Our claim is simply a due process at its basic requires a neutral adjudicator. And in this case, this whole case began, the very first order issued by Chief Judge Moore says on page 2, I believe, of that order, says that the reason this process has begun is because other judges supposedly have complained about Judge Newman's alleged infirmities on the bench. So there are witnesses. It's not so much even, although that's also a problem that they're both prosecutors and judges, but they're witnesses, and then they're evaluating essentially the veracity of their own statements, which is why, as we pointed out, so it's not an equal protection challenge. It's an understanding of what the statute allows, which is why in every other case that we've been able to find, and police have not been able to point to anything contrary. In every other case, when a circuit judge was being investigated and when it went beyond the chief judge evaluation, when it went to special committee, it's been transferred to another circuit. In fact, transfers have happened when, even for district judges, when they live in close quarters, as just happened for a judge of the DC District Court. And so it's the due process is not that this court should superintend every single circuit that does something screwy. It's that at the very least, the people who are adjudicating the dispute, whether it's about disability or about misconduct, have to be neutral in their neutral adjudicators.
Is that a facial challenge or is that an as-applied challenge?
It has to be sort of as applied challenge, but it's one of those things that it's a basic constitutional requirement. Of course, it has to be as applied because you only know whether or not due process is violated based on what actually has happened. So you have to wait what happened. But
We're obviously back to McBride, which
We're
also
back to
involved a due process challenge to the
Right.
way those proceedings were conducted.
right, that's true. Although there it was the only question was whether or not the proceeding should have been started to begin with, and not whether or not the ultimate adjudicators are essentially conflicted out. But
Mr. Dillon, you said that there's no examples of a misconduct investigation conducted within the judge's own circuit. On what basis are you talking about published judicial decisions?
well, yes, because published judicial council decisions, because once an investigation begins, once it goes past the chief judge. So it's a 3 sort of step process. There's a chief judge who can kind of give thumbs up or down, and then if it moves to special committee issues a report to go to judicial council. Once it moves to the special committee, and special committee makes some sort of recommendation, judicial council must publish a report. So whether it exonerates the judge or punishes the judge. So yes.
But there can be, and you're distinguishing a case in which there may in fact be an investigation short of the judicial council.
Well, that could be essentially what's a quick look where the chief judge says this has no merit and it goes nowhere. So there's really not really an investigation. But anything that's really an investigation when there's a disputed question of fact has always been transferred somewhere else. And the way we know this is because there's not a single published decision, and our police have not been able to identify one where things stayed in the circuit. The closest they come is they cite the Adams case from the 6th Circuit. Of course, Judge Adams was a district judge, but even there, every single judge in his district recused himself. And not only that, but then Chief Judge of the 6th Circuit, who before going on to the 6th Circuit, served on, not even with Judge Adams himself, but with his colleagues, served on the Northern District of Ohio because she knew personalities involved. She recused herself. So same thing just happened in Alaska where the circuit judge from Alaska and the senior district judge, because they all sit in the same courthouse with a judge who was being investigated. They recused themselves from judicial council. This is just de rigueur. It has never happened otherwise. And in 2+ years of this litigation, appellees have not been able to point to a single case where there has not been a transfer.
Do you distinguish between, or is there a distinction between the power or the authority of a court to do the investigation itself without transferring it? Is doing the investigation itself a violation of due process, or is it acting on the outcome of the investigation?
I don't think those two are separable because part of the investigation is also taking evidence. It's also potentially expanding the scope of investigation. It's potentially issuing interim orders. So I don't think those two are really
Due
distinguishable.
process rights with respect to an investigator are very different than they are with respect to an adjudicator.
Correct. But I think
You're not entitled to.
you're
know,
right.
I think in a criminal context, which is definitely is not, but, the police are investigating because they think you did it.
Right. But of course, you're entitled to sort of a prosecutor who's not conflicted out. But I think the weirdness of this whole thing is that investigation and adjudication all happening at once with the same people involved. And so,
It's not the same people. The council included many more people. The investigative committee was pretty small, as I recall, three.
Three, yes.
People.
but of course, those people are also on the council.
I understand that. But the three investigators, it's not the same people making the decision by the council that are doing the investigation.
Yeah, correct. But I think in this case, at least, it doesn't matter. Well, it doesn't matter for two reasons. One, because the investigators also get to issue what they view as binding orders. And it's because they view Judge Newman as being disobedient to those orders that they've imposed additional sanctions. But also, and I go back to this notion that from the very beginning, there was, and this is not us, this is Chief Judge Moore in her opening order, says that other judges have evidence that Judge Newman is not able to do her work. So she has not identified which of those judges are. So for all we know, it could be the investigators, it could be people on the council. And that is ultimately the problem on the due process issue.
Can you update us on the status of the ongoing proceedings?
Uh,
There's a pending motion for reconsideration,
It-
back and forth.
It remains pending. There's additional reports have been submitted. Some of them are now published on the Federal Circuit's website.
Still pending before the council.
Still pending before the council. Given the latest public order, we don't have much confidence that that they will reconsider. And in any event, we're coming up, by the time the reconsideration happens, we're coming up now on potential renewal for a third year. So if the council does not buy Dr. Filler's report.
What do you think either an investigating committee or a council can do? What do you think is permissible for them to do if a judge engages in misconduct as part of an investigative process?
They can use all the sanctions that are available under Judicial Disability Act, but remove the judge completely from hearing cases. They can, of course, refer the matter to the
Give me an
House.
example.
Sorry?
So, all right, so they could refer it for impeachment. That's, okay, I assume that that's not the only option. And
Okay.
so they can, what?
There can be reprimands. There can be, depending on the misconduct, the council could choose to say that, look, with these particular lawyers, you don't get to hear cases because you've been misbehaving
No,
towards
but
those
here
lawyers.
The misconduct alleged here is that the non-cooperation with the investigative process. And so how they need to do an investigation. You haven't I know you've challenged who should be doing it, but you haven't challenged that there was at least a legitimate basis for an investigation here. It's just your objection has been who does that investigation?
Well, we have challenged it, not on this court, but we have challenged the basis for the
Your
investigation.
argument
all
to us
right.
is who does the
Right,
investigation, not
correct.
whether there should be an investigation, so I'm taking it on that basis. Okay? And so, and then when someone doesn't cooperate with the investigation, what are their options? Because a reprimand doesn't get them the information they need to conclude their investigation.
So there are also mechanisms in the statute that allows the council to go to a district court, which would be a neutral adjudicator, and get a subpoena, which would be enforceable as any other subpoena, including
They
by
don't
civil.
want documents, they want a medical
Well,
examination.
Well, they also wanted documents as well. So they wanted Judge Newman's medical records as well. So
I
but
thought
they-
those were provided by now. Have they not been provided?
they've been provided just to the experts. They've not been provided to the council, which is another point of contention between us and the council.
Can one subpoena, by subpoena or other judicial process, require someone to undergo medical examination?
Well,
Yes.
certainly in other contexts, yes, we've, certain criminal contexts, we order people to to undergo examination for competency, we undergo examination for insanity, we undergo examination for, to provide blood work. So certainly that can be done.
Isn't
But-
this
Civil
then
context.
a less, right, in the civil context? No?
Well, in a civil context as well, I think you can order, for example, blood work to determine paternity.
What?
To determine paternity, for example.
Attorney. So you characterize this as a, effectively because renewable, a permanent bar on the judge doing work on the docket, but it seems significant that neither have they ordered her to undergo medical examination per se, nor have they ordered her to stop hearing cases. They've given her a pressured, to be sure, option. If you don't submit to the investigation, then you aren't hearing cases. But if you do submit to the investigation, then you may continue to hear cases.
Well,
So it's different from a permanent bar.
So I don't think that's true for two reasons. And I think your question has one of the reasons embedded in it. And that word is may. At no point did Judicial Council suggest that if Judge Newman goes through the investigation, and in fact, if she passes with flying colors, she goes back on the bench. That has never been suggested in any of the Judicial Council's orders or any of the briefs. So like that will merely allow us to conclude our investigation and come to our conclusion, which will ultimately get on our own, including all the affidavits from the court staff, including apparently our own views as judges and our interaction with Judge Newman. So
If they were to say, and if, as you put it, she passes it with flying colors, she will return to her duties. If it had said that, would that be a cure for the constitutional
I
defect?
don't think so. And this
Why
goes,
not?
and so this goes to Judge Millett's initial question. What is the Judicial Council to do? And I respectfully submit that there's only three ways for a judge to stop hearing cases, and that's death, resignation, and impeachment. There simply is no door number four. And so if the judge is recalcitrant, if the judge is refusing to comply, if the judge is, in fact, if the judge is disabled, which Judge Newman is not, but if the judge were disabled, removing a judge from hearing cases simply by the order of her colleagues is not what the Constitution provides. In fact,
Wait, but being disabled is not a high crime or misdemeanor.
well, of course, the Congress can determine for itself, and that actually is not judicially reviewable. What is high crime or
I
misdemeanor?
know, but just thinking about what the Constitution means in providing for impeachment, I mean, nor is having whatever impairments the committee of, the Judicial Council of the Federal Circuit is investigating. That's also not a high crime or misdemeanor, nor even interfering with an investigation, I don't think. And so the notion that what's available is death, resignation, or impeachment leaves the courts with no ability to govern themselves
But that I think is by
in the
design.
interest of the public.
But I think that's by design. The Constitution provided only three ways to protect the public from wayward judges, and that is death, resignation, or impeachment. And yes, that comes with some costs. And in fact, whether or not disability is high crime or misdemeanor, the concept of disability was considered even before the Constitution. Alexander Hamilton writes in Federalist 79 that it is better to occasionally risk a disabled judge being on the bench, in part because mental disability is such a amorphous line, than to have any mechanism for removal. So Judge Millett, to your question, fundamentally, what's the remedy? The remedy is what the Constitution provides, and that's impeachment. And I think that's a
If
high
they
bar.
issued a subpoena for all of her medical records that were submitted to the expert or whoever what they were submitted to, would that be permissible?
Yes, that's permissible because that's done under Article 3 power of a neutral district court, like in any other civil proceeding. So Judicial Council would file a civil action against Judge Newman, but ultimately, the bottom line, whether they get the medical records or not, whether they adjudicate Judge Newman to be competent or not, the bottom line is they still cannot remove her from hearing cases. If they think that she's
So
incompetent,
the
in fact,
statute gives, I don't know why they have to go to district court. 356 gives subpoena power to the councils and their special committees.
yes, but it's enforceable in a district court. Like there's a separate next subsection.
They can
saying-
issue the subpoena.
They can issue the subpoena, which of course they've never done. And if we contest the subpoena or if we ignore it, they get to go to the district court. So it's
Right,
enforceable
but
in
they
district
don't
court.
have to go to district court to have the subpoena.
Correct,
They can issue
right.
the subpoena.
Yes, that's true.
And if she doesn't comply, what happens?
Then they have to go to district court for enforcement.
And what's the enforcement?
The enforcement is through civil contempt. But I also wanted
Is
to,
civil contempt and misconduct that the council could take action on?
no, I think the district court could take usual actions, whether it's monetary penalties or whether it's jail
I understand,
time,
but someone's held in contempt by a court.
right?
I would think an investigating judicial counsel would be able to investigate that.
Oh, absolutely. That,
Misconduct.
yes, of course.
warranting-
Oh, of course. The question is, what punishment can they visit on Judge Newman? And the punishment is not removal from hearing cases.
No, but it could be, I mean, in civil contempt cases, there's pressure put on the person until they comply.
Yes.
Um,
And so, yes, so if a district judge wishes to jail Judge Newman until she complies, that's a different story because again, it's done under Article 3 powers and she's basically treated as any other
In
litigant.
jail, they can have fines accrued.
They can have fines
at a
accrued.
rate, And but it's your position that they cannot touch the assignment.
Right. She's vested with judicial powers through the Constitution. That's where she derives her powers. Those powers cannot be withdrawn by simply by an order of an administrative body.
So this is not at all a comment on the existing case before us. We're just exploring your view of what powers the judiciary has to make sure that it is serving the public as intended. If I had a serious brain injury and could no longer speak coherently, but came into the office and continued to do my work. And my colleagues had concerns whether it wasn't just a speech problem, but a bigger problem of brain injury. If the court wants to investigate in its responsibility to make sure that the Article 3 courts are serving the public, the only thing the court can do is imprison or fine that judge when they don't submit.
Well,
Subpoena the judge for medical records.
yes. So I don't
The
think
judge says, I don't want to give them, or maybe I haven't been and had that examination.
so. Well, they can't imprison or fine, so that's not a power given
So
by
you go to the
but
district court,
yes,
and
and
you get
district court. Right.
enforcement, and to you, it's less of a constitutional problem for the district court to fashion a contempt sanction against a circuit court judge than to have the Judicial Council appealable to the Judicial Conference of the United States do something analogous.
Indeed. And the reason it's a lesser sanction is because in that hypothetical, the district court is not directly affecting your Article 3 powers. Now, you may be sitting in jail and therefore can't show up to the courthouse and can't adjudicate cases because you're physically not there. And so it's an incidental effect on your powers, but not a direct effect. So your powers as a circuit court judge stem from the Constitution and the commission that you were granted after having been nominated by the president, confirmed by the Senate, and then appointed.
So could the council, as a sanction for misconduct, bar a judge from entering the courthouse?
From being in a courthouse?
Mhm.
So as we said in our brief, the Constitution does deal with substance, not shadows. So if it's merely,
Well, you just said if a judge, by virtue of contempt, prevents her from coming to the courthouse and hearing cases, that would be just an indirect effect, that would be fine. But, so if the circuit council just prevents her from coming into the courthouse at all, then it would just be an indirect effect. Any impact on her ability to hear cases would be an indirect effect.
I think I disagree because,
It's a direct effect when the council does it, but it's an indirect effect when the.
well,
district
I
court
think,
does it.
I think the point is that if it's sanctioned for misconduct, so as to prevent the judge from hearing cases, not so as to, not so as like to treat her like any other litigant who.
They will say that they've done it because, say you have, obviously not this case, but you have someone who's just really loud and noisy and pulling a china shop whenever they're in chambers, and they go around throwing things and breaking things and yelling at other people. They go, you can't be in the courthouse. You can't be in the courthouse. We have to
Right.
protect people from that.
The point is that the judge would have to be, whether they get to sit in their chambers, they would have to be able to go on the bench. So
Well, then
simply.
why
right.
wouldn't that apply to the same? I mean, I'm not understanding why you think a district court can accomplish something that the council cannot. If they're both, you just said it was
Right, so-
indirect.
so-
That's not a problem. This would be it would be justified on the facts. They can't function
Right,
in
so I
a
would answer,
professional manner physically inside the courthouse. That's not this case at all, to be clear, but
Yeah.
that by hypothetical. And so the same thing is you can't come in this building. You
so I would answer it
Right.
by analogy. So if, for example, a district court, not even in this context, in any other context, a judge
Why
is.
is it different
Right.
when the council does it than when a district court does it for contempt?
So if I may, Judge Millett, so by analogy, imagine a district court finds a judge, whether it's for speeding or for whatever else. Now, in some sense, it diminishes the judge's salary, right? Because now she has a smaller take-home paycheck. That is not a constitutional problem because the judge is simply being treated like any other litigant. But conversely, if judicial counsel says, look, you're being too slow on your opinions, and so we're docking 10% of your salary, that is a constitutional
No, if
problem.
they said you broke all the dishes in the cafeteria, you need to pay for them. They could do that.
They could do that, but that's not
So
so.
I don't understand how that answers my question about if a district court prevents someone from coming into the courthouse, which is necessary to hear cases, then why the council couldn't
Because
likewise impose sanctions that prevent someone from coming into the courthouse and have the indirect effect of preventing them from hearing cases?
But even when a district court does it, even the preventing from coming to the courthouse is itself indirect because the district court presumably would put a judge in jail. So it's not an order you can't come to the courthouse. So you have to sit in jail.
Or
And-
issue an injunction.
I don't know if so if the district court issued an injunction preventing a judge from doing her job directly, that would also be a
No, you
constitutional
can't go
problem.
into
Like,
the courthouse.
but I think that would be a constitutional problem if you can, because if you need to be in the courthouse
They
to
put-
do
so
your
they can-
job.
They can only put you in. All right, it doesn't make a whole lot of sense to me that the Constitution's perfectly happy if they can't sit on cases because they're in a jail cell. But otherwise, any other thing that keeps them from coming into the courthouse to hear cases is not allowed.
I think that's right. I think
It
the
doesn't make
Constitution.
much sense to me.
Well, if it were right, Judge Millett, then the impeachment provision in the Constitution that is meant to be a high bar essentially becomes unnecessary because judicial counsel can always withhold.
Well, again, I know you talked about this. So the impeachment standard is high crimes and misdemeanors. Article 3 protection is serving during good behavior. Are you equating good behavior with high crimes and misdemeanors? It seems to me that they're somewhat different in there, and that may very well be the area in which this council operates.
Whether or not they're the same, I think it's.
Well, that's what you seem
right,
to, your
right.
argument assumes, right? That
But-
the only thing that prevents you from hearing cases is impeachment,
Correct.
removal. But that's not what Article 3 says. It says service during good behavior.
Yes, but I think
Is good behavior the same or not?
I haven't given it much thought, but I don't think it matters because whether or not good behavior is a higher, same, or lower standard than high crimes and misdemeanors, the judgment as to whether or not somebody is on good behavior is with Congress and not with fellow judges.
That's not, no, the Congress gives them an impeachment power, and it doesn't say you decide if they're on good behavior. It says you decide if they've committed a high crime and misdemeanor. So that's why I think it may very well matter that these seem to be different standards. And so if it's good behavior, which of course committing a high crime and
Right.
misdemeanor would not be good behavior, like that's easy. But if instead someone is critically ill, has had severe physical injuries from some kind of accident and simply, cannot move, is going in and out of consciousness for 3 months. That's not a high crime and misdemeanor, as Judge Pillard said. but their ability to serve during, you know, good behavior in their service might well be in question, at least during that time period while they're recovering.
Yes, but presumably in that situation, the judge is not on a course. So judges, of course, like everybody else, can take medical leave.
That
Judges,
judge
of course,
is
like-
not capable of making any decisions in my hypothetical. So that they're not going to voluntarily do it. They're not in a position to make any legal or binding decisions. So the council itself will decide, we are not giving that judge any cases during the recuperation period. We are not going to have them voting on bank matters during the recuperation period. That seems to me fully consistent with Article 3,
I think it's only
fully
consistent,
consistent with what the statute allows, even though there'd be no reference for impeachment.
but I think that in that case, the reason it's permissible is because the judge is simply not there to do the work, right? So in your hypothetical, the judge is going in and out of conscience, presumably they're not showing up at the courthouse. Judge, but if I could go back to your prior question, but
I just, in exploring the apparent gap between service during good behavior and high crimes and misdemeanors, you said at one point that would be for Congress to judge. And I wasn't sure whether, I mean, the ensuing back and forth seemed to take that to mean in serving articles of impeachment. But when you first said that, I thought you meant for Congress to judge in legislating, for example, enacting 332 or the different authorities that are given.
no, in the articles of impeachment.
Pardon?
Through the articles of impeachment, not
In
Congress.
articles of
Yes,
impeachment. So is it not the case that
apologize.
Congress has any role in ensuring good behavior by legislating? If, and I know you disagree with this, or I gather you disagree with this, maybe the threshold question is, do you disagree that there is an apparent delta between conduct that refrains from committing high crimes and misdemeanors and conduct that constitutes good behavior? You see
That,
those as identical?
yes, I do disagree. There's a delta simply based on historical standards. So Congress has never thought that there is
Well,
such a delta.
Congress did enact various authorities, and we've held them to allow certain discipline of judges. So, and Congress hasn't amended those authorities for the Judicial
Cor-
Council to supervise and to some extent discipline judges. So somebody thinks that there's a delta, or tell me why that's.
No, so I think I disagree. And I disagree for the following reason. The judges get to hold office during good behavior. Holding office, as I've said before, includes determining judicially questions submitted. That doesn't mean that judges don't get reprimanded. It doesn't mean that judges don't get, don't get assigned, not assigned some cases, but not others. So, but you have, the good behavior protects the holding of the office portion. And Congress, the only way to stop a judge from holding office, i.e. from deciding judicially questions submitted, is through impeachment. If it were otherwise, it would then mean that Congress can delegate this role, not just Judicial Council. Congress can delegate this role to
No, but your theory leaves no room at all. I mean, this is a statute not just about misconduct, but about disability. And disability, if you do the impeachment process, you're out. There's no temporary impeachment.
correct.
And you are in fact convicted of a crime, right? You're going to lose your any pension you might have, any benefits. You lose everything. And the notion that Congress would say, well, if someone has a disability so they can't function for 6 months or a year, we're going to declare them a criminal and destroy their entire position, take it away, never to be returned, including all benefits and emoluments with it. That somehow the Constitution forced that choice seems to me an extraordinary proposition. And in fact, the standards are different for impeachment and good behavior. And that's the very reason there has to be room for some temporary suspensions that keep the person in their office, that don't take away their ability for retirement benefits or health care benefits while they're recovering. I don't understand why. I mean, if your position means that someone who is physically disabled for 6 months has to either be given cases to decide or impeached, that suggests to me there's something wrong with your position.
I think my position is that if somebody is disabled for 6 months, somebody undergoing medical treatment and,
And they
I know.
can't decide because they're going in and out of conscious. No one would let them sign a contract at that point, let alone say, please take me off the cases.
but they're also then in that hypothetical, they're not in the courthouse. But to Judge Pillar's point.
What does that get to do with being in a court? No, what? They're not in a courthouse. Of course they're not in a courthouse.
But they're not showing up for work. So of course, court can not assign cases to somebody who's not showing up for work.
What? Why? If someone doesn't show up for work, that should be a good reason for impeachment.
Well, no, because well, yes, and actually that has been, there have been 2
If they
cases where.
don't show up for work, the council still can't do anything. They have to be impeached.
No, the
They don't show up
council,
for work because they're in the hospital.
no, I think it goes to this idea that I think Judge Millett, you asked before, or actually with Judge Pillar's question, what happens if you're backlogged? You
I'm
are.
not asking about backlogs. What I am asking about is my scenario. And the reason they aren't showing up for work is they're in the hospital, going in and out of consciousness. And your answer is, wow, let's impeach them.
No, I think my answer is if the judge, it's consistent with our position that a voluntary agreement, so for example, a case
There's
that.
no voluntary agreement because they're not capable of entering into a voluntary agreement.
No, I
That's
understand.
why I gave you that hypothetical.
No.
So you have no voluntary agreement as an out. And so you've got, under your scenario, there's 2 options here.
No, I
We give them
understand.
cases or we impeach them.
I understand that there's no explicit voluntary agreement in your hypothetical. My point is it's consistent with that idea that if you're not there because you're sick or because you're going through treatment or because of whatever other reason or because maybe you had to take time off to attend to family emergency, it is fully consistent with the idea that of course when you're not in a courthouse, when you're not doing the work, no new case get assigned to you. But when you are there, when you are able to do this, when you're willing to do it, to withdraw case from you as a punishment.
The way that happens is, barring my hypothetical where they are not able to communicate or make legal decisions, if someone's going through a family matter, you know what you do? You go talk to your chief judge and say, I need a hold. That would be your voluntary situation. But that's very different from my hypothetical. And I still haven't heard an answer under your vision of how the Constitution works as to why the only answer to that is keep assigning cases to the person who's going in and out of consciousness for 6 months or impeach them. What is your third option for that one when there's no voluntary agreement?
So my third option is simple. I'll have to refer back to what I said before, that if the judge is not in the courthouse, if the judge is not actually doing work for whatever reason, you can stop assigning cases to
Okay,
them.
I
But
have a harder hypothetical, and we will at some point let you sit down and hear from opposing counsel. And this is sadly informed by a situation with an elderly relative who became paranoid and aggressive. And this person was not a lawyer or a judge, but I could see such an individual coming to the courthouse and being very belligerent and insisting on hearing cases, and in fact, having the sense that people who were trying to help her were, out to get her, and that she would lash out. I mean, that happened to my relative who broke up the relationship that she was in just when she needed it for caring for her, and alienated everyone. So you come into the courthouse, you insist on doing your work, you yell at parties, you yell at counsel, you are there, and the court, does nobody in the system, and is it a high crime or misdemeanor? It's certainly not good behavior. Is there nobody in the system who can take steps against a conscious, belligerent person whose judgment is clearly in trouble? And again, I am not suggesting
Right.
that this is the case
I appreciate
before
that.
us,
Right.
but the ruling that
Right.
we make could have effects on other cases.
I appreciate that question, just Paul. So, and in some sense, it actually goes back to what I wanted to return in your prior question about what if a judge had a stroke or whatever. Because police do cite a similar case, and we've responded to it in our reply brief. There was a similar situation like that on the 7th Circuit, I think in the Northern District of Illinois, where a judge did have a stroke, did not fully regain his executive function, which one would think is somewhat problematic for a judge sitting on the bench not having full executive function. And yet, nobody thought that they could fully divest him of judicial authority. Then Chief Judge Easterbrook simply chose not to assign him criminal cases, I guess on the theory that more is at stake in a criminal case than in a civil case. But that judge continued to sit on civil cases. And so I think that just shows that
You
there's.
haven't answered my.
Well, so I'm
scenario,
getting it
which is
right.
much harder, I have to say. I recognize it's very difficult.
Right. So, but I think it goes to, I was getting to the answer. I think that in those situations when a judge is belligerent, when a judge is, the answer is you could potentially reduce the caseload to alleviate the pressure, but you can't completely withdraw it. And if it really is a problem, if it really is that bad, impeachment. Ultimately, I think I have to fall back on the Constitution, and our founders contemplated this very scenario. They thought about it. Alexander Hamilton wrote because he said that, look, some states have actually taken a different route. So for example, at that time in New York, you had to retire at age 65 precisely because people were worried. And Hamilton writes that we are purposefully not doing that. And the upshot, if the answer is that somebody could, outside of impeachment process, take care of it, then there's no specific constitutional reason why it has to be assigned to judicial counsel, as opposed to, for example, Department of Justice or the White House. There's no specific, if you can essentially debar a judge from hearing cases short of impeachment on a temporary basis, there's no specific constitutional prohibition that says, well, it has to be done by fellow judges.
But there seems to be serious separation of powers concerns with having another branch be responsible.
Well, I think that those concerns are equally present when it's the same branch is doing it, because the concept of judicial independence is not merely independence from other branches. As the Supreme Court said, it's also independence of each individual judge.
This is a big debate in,
Right.
Chandler and the dissents and some of our cases. Was
But-
any of your historical evidence that you've referred to actually show they considered the possibility of intra-branch discipline?
I'm sorry, could you repeat the question, Garcia?
The Hamilton
Right.
and other evidence from the founding, does any of it actually speak to intra-branch discipline as opposed to inter-branch discipline, which obviously raises more of the types of separation of powers?
It doesn't speak specifically on intra-branch discipline, but Hamilton's basically says like we do not need any additional mechanism. But if it is not a problem to do it intra-branch, then the other problem follows. That would mean that because there's no danger of judges being, no danger of judicial independence from fellow judges, it would follow that, for example, an appellate judge could call a district judge and say, look, I need you to decide a case this way. And it would not be a problem because it's intra-branch, and that simply cannot be right. So I take your point. Of course, it's an even more danger if you assign this determination to the White House as opposed to intra-branch. But I don't think it's really different in kind. It's perhaps different in degree.
I just want to get back. You started with a list of, sorry, that you said their only option is impeachment. But then you said impeachment or voluntary suspension, right? You've agreed with that if they voluntarily need a suspension.
Yes.
And then you said impeachment, voluntary suspension, and they can't get into the courthouse.
I think,
That's, you added that. I
No.
don't understand the answer, but that's what you added.
well, I've added that you can't get as a secondary thing. If they're sitting in jail, they, as a result,
No,
sit in
that
jail.
wasn't
Like,
my hypothetical, wasn't jail. So
Right.
I gave you a hypothetical. They couldn't, and your answer was repeatedly that the person in the hospital can't get into the courthouse,
Right.
so you can suspend their work. Is that correct?
yes.
Okay, so you've got three things now. Chandler said that you can suspend it for being behind in a backlog of cases. Chandler said that. We're bound by that.
Well, I don't think Chandler quite said that. I think Chandler ultimately was decided on jurisdictional issue because
They
the court
said
said
it would be
mandamus.
perfectly fine.
But-
That would
but
be
all-
fair and made sense to be able to address a backlog that way. Now, you can say it was just dicta, and so but I'm not going to say they were just kidding when they said it. I feel like we're bound by it. So we've got those four things.
But I think you have to look at how it at the procedural posture of Chandler. So first, Judge Chandler actually agreed to case reassignment.
I'm telling you what the Supreme Court said, their words. That's what I'm telling you, right? They said, you agree they said that.
They did, but again,
Okay.
so I think, but part of, and I think actually it could have been an opinion by Justice Harlan as a concurrence and not the majority. The majority ultimately did it on the mandamus, saying that there's
I
no
understand that.
disputable
But so you
right.
think they didn't mean it then? We don't have to take
I-
it seriously? that the
No, I
statute is
don't
okay?
think, I don't think majority endorsed the idea that you can, without judge's consent, simply take away his function. The majority said that on that case, on the facts of that case, when Judge Chandler repeatedly agreed with his judicial counsel on case reassignment.
Many courts, including federal courts, have informal, unpublished rules which, for example, so there's other ones, provide that when a judge has been given a number of cases under submission, he will not be assigned more cases until opinions and orders issue on his backlog. These are reasonable, proper, and necessary rules, and the need for enforcement cannot reasonably be doubted. And you're saying we should pay no attention to that?
No, I'm not saying that. In fact, Federal Circuit has that rule as well, and we're not
Okay, then,
challenging
so
that
that's a
rule.
fourth exception.
No, I don't think it's an exception, because in those cases, I think we started with a conversation with Judge Pillard a while ago, because in that case, you're not suspended from determining judicially questions submitted. You still have cases you're working on. You still have opinions.
They can
You-
suspend new assignments.
They can suspend new
Right.
assignments,
Okay.
right? And I think that goes to Judge Garcia's very first question about how to distinguish McBride. And the point is that, or how to construe the statute. If all the statute allows you to do is to essentially suspend new cases while you still have other judicial work, that's fine, because you're still holding office, because you're still exercising judicial powers of the United States. But if you have no work to do, as Judge Newman has not had it for almost 2 years, not petitions,
So if they allowed one case a year, you'd have no objection?
I think it would be a harder constitutional question.
I want to know your answer if it was allowed one case a year.
I think, like I said, it would be a harder constitutional question. I would have to think harder about it, because again, ultimately,
She's not
it's
being
right,
completely
it's
deprived of
substance,
Judicial power.
right? It's substance, not shadows. And so if it's, but so long as she has some judicial work to do, then she has not been functionally removed from office.
So one case a year would not be a function.
I would have to know like how long that case will take. If she has some judicial work to do, but it can't be just like she has, does work for 3 days and no work for 362 days. So, but I think that as long as a judge has exercises judicial function.
Article 3 requires some volume of work.
Article 3 requires the judge be able to exercise.
Yes,
Right,
I
but-
understand that. You're
but-
saying
so-
exercise judicial power. And it sounds like you want to say, well, more than one case a year. But somehow we're supposed to
Right.
just.
No, so I think I agree that it's a very hard to draw line, but wherever the court draws that line, we're way past that. So whether it's, whether one case a year is enough, or whether it has to be like once every month, or similar to what other judges in active status are doing, wherever that line is drawn, at the very least, Judge Newman has to exercise the powers that the very commission that's hanging on her wall, and very commission in which the appellees rely, invest in her. And thus far, since at least November of 2023, she's had not only no cases, not only no petitions, she has even been removed from the court listserv that allows her to see pre-publication opinions of her colleagues. She's doing absolutely no work whatsoever. In fact, the appellees in one of their orders say, and as a defense of the argument that Judge Newman has not been functionally removed, said that she has been invited for ice cream socials, and she gets occasional emails about patches to the IT system. That cannot be what the Constitution envisions an Article 3 power to be.
Any question? Okay, thank you very much.
Honor.
Walter. We'll hear now from Jessica.
May it please the court, Melissa Patterson on behalf of the Federal Circuit Judicial Council. And I would like to start this morning by making clear that no one in these proceedings is disputing Judge Newman's many contributions to the law generally, or the Federal Circuit specifically, for decades before the concerns arose that resulted in the Judicial Council order that's issued today. That order was issued under the Judicial Conduct and Disability Act, whose review provisions this court has previously addressed in McBride. And in McBride, the court held that if you want to go to district court and bring a challenge to the type of Judicial Council order at issue here, there's only one type of challenge you can bring, and that is a facial challenge to the act itself. For all other complaints, whether they are about statutory matters or as applied constitutional challenges, you have to use the review mechanism that Congress created and crafted in the Act. And that is a petition to the United States Judicial Conference.
The problem, as you know, is the Judicial Conference has said, we can't hear as applied claims.
And they have
And
since
this court said, we can't hear as applied claims because they need to decide the as applied claims. And so McBride, the combination of McBride and the position of the Judicial Conference has left us with a world in which there are constitutional claims that can't be heard anywhere. Isn't that, if that's what this statute creates, isn't that a constitutional problem in its own right?
that is not the state of the world, Your Honor. The Judicial Conference can and does entertain as applied constitutional challenges since this court in McBride said it
No, but they
could.
said here, they said, when they described exactly, what their standard of review is, what they would review, and it was not, it was not.
I believe it's
as
legal
applied.
error, which of course includes constitutional challenges, clear error of facts, or
Did they
abuse of
did they
discretion.
address her as
Yes.
applied constitutional argument in this case?
Absolutely, Your Honor. I refer, in February 2024, Judge Newman's petition to the Judicial Conference, which had been referred to the Judicial Conduct and Disability Act, which is composed of 7 Article 3 judges from the 26, 27 who populate the Judicial Conference. And I refer the court to pages 14 through 21. So on page 14, the committee describes the challenges that it has before it. And it recounts that she says the Judicial Council's alleged, quote, violations of the Act, the rules, and the Fifth Amendment constitute good cause for her refusal to submit to medical testing. And that the sanction imposed by the Judicial Council, the 1-year suspension that's been under discussion this morning, is contrary to the Constitution. It then goes on to reject those challenges on the merits. It
No
says,
mention of the Constitution is there. It says all the process she was due under the rules, not under the Fifth Amendment. There's at least some ambiguity about whether they thought they were resolving the arguments, the constitutional arguments they described.
I think it's quite an implausible reading of this opinion to take the view that what the Judicial Conference did was say, we have before us a constitutional challenge. For it to go on to analyze and to say, quote, Judge Newman was not denied due process, to describe the many processes afforded her under the rules, to say, in fact, the Judicial Council here gave her more process than those rules decided. And then for the inference of all of that to be that the Judicial Conference, the Article 3 judges there, actually thought, we are going to silently not address the due process challenge of the constitutional variety we referred to several pages before, and to leave that uncorrected, despite the fact that we are possessed of uncontested authority to change any of the sanctions that the Judicial Council ordered. Were there any doubt that the Judicial Conference Committee considers itself capable of resolving constitutional challenges? It did so in the Adams case. We cite this in our briefs. And I don't think there's any possible ambiguity in this statement, Judge Garcia. The Judicial Council order, quote, did not violate the Fourth Amendment regarding the mental health examination and orders. So I think it
Where do they
is,
address the due process implications of not transferring?
pardon?
Where do they address the due process implications of not transferring? They sort of go through recusal issues under statutes. But where do they say, address the due process issue of having someone who has information about either actual or perception of bias or relevant information in the case? I mean, her whole argument is, you can't adjudicate my case if you are a witness, if you have firsthand knowledge, or if you have potential bias, or even, there could be an appearance of bias. Why is that? Where is that addressed?
I would direct the court to pages 15 through 20 of the Judicial Council decision. This is the internal pagination for the committee decision itself. The court notes, Judge Newman concludes that recusal in this matter is both constitutionally and statutory required. For the reasons explained below, we conclude that neither the Circuit Judge nor the Judicial Council abused their discretion by not requesting transfer. It then goes on to explain that in the system Congress has created, the sort of rules of 455 recusal do not apply, that the design Congress has
Doesn't
created.
that- if They don't go on to then say, well, whatever the rule is that applies, that's not the same thing as saying, what does the Constitution require? And they don't go on. There's no constitutional cases. And here there's no constitutional analysis. As we said at McBride, they've disavowed their ability to decide as applied constitutional claims.
Well, in McBride, of course, the court still refused to entertain the as-applied challenges, even when we were in a state of the world where it was uncontested that the Judicial Conference
Right.
was not going
You
to.
said the Judicial Conference has now changed its practice. Have they
Yes.
issued a new document that says we will decide as applied constitutional challenges? Have they announced that they will decide it?
I am unaware of any such document,
Right.
but
and then
in
you can't
their,
read these opinions and think they're actually deciding anything constitutional.
I most certainly do, Your Honor. And if, were there any doubt, and I don't think there's a fair doubt, that the judges of the committee understood themselves to be resolving the challenges they described before them. I think the Adams decision, where there was an unambiguous rejection of a Fourth Amendment challenge, puts to rest any idea that the Judicial Conference is somehow disabling itself from hearing these claims.
Is the JC&D committee or the Judicial Conference your client in this case? Or
The Judicial
Council?
The Judicial Council is my client, yes.
And so, at least as to them, you're representing that they believe, and for example, if another challenge is raised, they're going to address whether this has amounted to an effective removal that violates the separation of powers.
If the question is, do my judicial clients believe that they are adhering to the Constitution and applying this act, the answer is unambiguously yes.
The simpler way is they believe they have the authority and they will resolve as applied challenges.
Yes, and of course, the Judicial Conference can then review their evaluation of the situation they have before them. I do want to return.
Do you also represent the conference?
I do not. I represent the council. I do want to return to McBride because I think that the colloquy earlier about what may or may not constitute a facial challenge is something I'd like to weigh in on. All of the cases that Mr. Dolan is citing about narrowing constructions being appropriate in a facial challenge are First Amendment cases. And this court has, I think, in many a recent case, explained that overbreadth is limited to the First Amendment. And that's because, of course, if you leave an overbroad statute on the books that has both First Amendment compliant and First Amendment non-compliant applications, you can chill speech. And in that particular context, given the need to avoid chilling First Amendment activity, you can, even in a situation where there is no as-applied challenge for whatever reason, take the face of the statute and cut it down. We do not have a First Amendment challenge here.
I mean, are you saying there can never be, you can never construe a statute to avoid a constitutional problem in a facial challenge outside the First Amendment?
I don't think opposing counsel has pointed to any examples.
I'm asking you whether, I don't understand why. I mean, you would have to find a substantial facial constitutional challenge, and you'd have to find ambiguity that could be interpreted to avoid that problem. I don't understand why courts' duties to avoid constitutional rulings when possible wouldn't apply equally to facial challenges
Well, I think as the Supreme
outside the First Amendment.
in Solerno, when what you are doing is changing Congress's handiwork, not just saying it's been applied unconstitutionally in this circumstance. Everyone agrees that in the normal course, that's how you would get at that problem. But when you are actually altering legislative enactments, the only time it's appropriate to do that is the no set of circumstances in which Congress's actual words could ever be applied
I'm just
constitutionally.
asking a question. If you're sitting there scratching your head, there have been statutes where like, we are really struggling to figure out a single example that would be constitutional. But if we read this word to mean X rather than Y, we could do that. And your position is that's not available.
I don't know that I have a position on that, Your Honor, because
Well, you were just saying that you were saying, pushing off his constitutional avoidance argument, saying that's just a First Amendment argument, and that's what I'm pushing back on.
I'm articulating the Solerno standard, which is the
I'm
standard.
aware of the Solerno standard. I'm saying you could be in a case applying the Solerno standard and have a substantial constitutional question in front of you under that standard that could be avoided by construing language in the statute.
I'm having trouble reconciling that with the facial nature, and here's why. If what you are doing is narrowing an act, you're issuing a narrowing construction, by definition, that means there are many constitutional applications of this statute. Now,
Only if you read the statute language as having that narrowing meaning, but without that narrowed meaning, you wouldn't be able to think of a situation where it would be constitutional.
Your Honor, I don't want to quarrel with this court's authority to read statutes in the way it
So it
sees
seems to
fit.
be the easier answer question
What-
here is whether they've raised that type of substantial question.
I think
under a
it's-
facial challenge.
I think it's clear, and think it was clear from the opening minutes of Mr. Dolan's presentation, where he referred to the council here functionally affecting removal, that this was a statutory violation of the temporary requirement in 354A2A1, and that, quote, these proceedings violated due process, that we do not have a true facial challenge before this court. What we have are precisely the type of as-applied challenges that Judge McBride tried to bring and that this court said had to be challenged to the Judicial Conference. The Judicial Conference can address Judge Newman's claims if she believes that the Judicial Council has exceeded the boundaries of the statute. It can address her claims if Judge Newman considers the application of these statutes, which are valid on their face, to have strayed outside the bounds of the Constitution. But under this court's binding precedent, that is a question for the Judicial Conference, not a district court.
So is one way of putting this that when you look at 2A1, everyone seems to agree that you can understand what it means in a lot of applications and that a lot of those applications are totally constitutional. And if we start from that point, do you think that we even have to interpret what the outer bounds of the statute are? Or is your point that no, everything I just said is enough to resolve what we've always regarded as a facial challenge?
That, Your Honor, yes. As soon as you have the undoubted applications of the statute in 354A2A1, that's all this court would need to resolve. And so I do want to note that I think some of the discussion, most of the discussion earlier hinged on the idea that you were not deciding any cases. Of course, for the first few months of the suspension, the one-year suspension, Judge Newman continued to hear cases because she had a backlog that she was working through. And the suspension was only of new cases. So even on her own theory, this very suspension would have been constitutional between September and November of 2023. And it was only at that point when Judge Newman cleared her backlog that this very suspension would have crossed their line from constitutional into unconstitutional. So I think that's enough to show that there are not only many theoretical applications of the statute that are constitutional, but even on their own theory, this one was for some period of time.
Can I ask a few questions about McBride? You might be right that we're bound by its jurisdictional holdings, but it seems like an outlier in several respects. And I think maybe one of them is, are you aware of any other statute a court has interpreted to bar as applied constitutional challenges, but not facial challenges?
I'm not, Your Honor, but I think that this may be an outlier because the scheme is an outlier. Of course, the actual language of 357C does not have a sort of a bifurcation. And you're right that usually there's a high bar to courts acknowledging that Congress actually means that, and that they will read in an implicit exception for as applied constitutional challenges. But McBride went very carefully through and acknowledged that high bar, said, yeah, we have to have clear and convincing evidence that this is what Congress meant and that it's okay. And the McBride court did that work. It explained we have a singular context here of the sensitive business of looking into Article 3 judge misconduct or disability. And we want to give that to Article 3 judges, but in order to protect judicial independence, we want to keep it out of the adversarial proceedings that if we put this into an Article 3 court, instead of just in front of Article 3 judges, who of course have all the life tenure and independence, and there's no reason to think that they would scant the right of their members of their own judiciary, in this context, where Congress has created a route to Article 3 judges, we think it is okay to read the language of 357C to mean what it says. We don't see a question that there is a meaningful difference between having as-applied challenges of this variety in this context reviewed by Article 3 judges of the Judicial Conference versus Article 3 judges of a district court or a court of appeals.
Well, the main concerning outcome here, this is maybe related to one thing Judge Millett asked about, is that you could have an extremely profound as-applied constitutional challenge. And sure, a body composed of Article 3 judges would be able to consider it. But as I understand your reading of McBride, the Supreme Court would not be the last word on that question. Say there really was a judicial order that amounted to what everyone agrees is removal. The Supreme Court wouldn't get to weigh in on that.
I assume by everyone, you mean everyone but the 26 Article 3 judges of the Judicial Conference.
And the Supreme Court would not be the last word on a profound question of constitutional law.
I think that is the result under this court's precedent holding that exercises of counsel power are administrative and not and therefore I think under the question the court left open in Chandler, not subject to Supreme Court review by mandamus. I know per the footnote in our brief, we have reserved that is an open question. If you considered the type of power being exercised by a counsel in the conference to be judicial, I think the Supreme Court would have the ultimate supervisory power over that. So we take this court's
Just by
precedent.
mandamus.
I believe so, Your Honor, although I haven't investigated the mechanisms. And in part, that's because we've taken this court's precedent that it is a form of administrative power as a given. But in McBride, this court fully embraced the
What
administrative.
power can violate constitutional rights and not be challenged.
I'm not sure I understand the question, Your Honor,
So, I
but
mean, the fact that it's, I don't understand why whether it's administrative, you consider it administrative or judicial, you have a proceeding here that the theory seems to be that they can address as applied constitutional arguments. Well, they don't seem to be doing it, but even assuming they could, and the Supreme Court can never review it.
I think that is if you consider this them to be
Administrative
exercised.
judicial doesn't seem to me to be, your answer seemed to suggest that because it was administrative, it made sense
Oh,
not to allow judicial court review or Supreme Court review of constitutional claims in a way that we would never say if it were a judicial body.
to be clear, I think it makes sense whether or not you consider this administrative or judicial
Okay,
power.
misunderstood you then.
What I am saying is that in Chandler, there was a big fight and there was the Harlan dissent about whether or not the court had jurisdiction to review the Judicial Council order. It was a 332 order because it predated the act. The court leaves that unresolved. And Justice Harlan explains that he thinks it should be judicial. And by his lights, he thinks that means the Supreme Court can issue mandamus. My only point is that to the extent that Judge Garcia is concerned about the lack of Supreme Court review, I think that is a function of the way this court has described the nature of authority issued. But let's assume this court is correct about that. I think Congress is entitled to vest this type of dispute, this type of constitutional dispute about Article 3 judge misconduct and disability in a body of Article 3 judges who are not sitting as a court. I don't think there's a constitutional problem with doing that. I do want to.
Without any review. And I'm curious as to why mandamus would be sufficient. Then the Supreme Court would only be able to correct clear and indisputable constitutional violations.
Like, Your
Not
Honor,
other ones.
I know that there are, under our Constitution, under different constitutional powers, there are things like the courts martial, which I believe until at least the mid-20th century, there was no Supreme Court review over a final court-martial judgment. So it is not unknown in our
Yeah, but
constitutional
there's-
system.
What history is there of decisions made by Article III judges, not military judges. And you're not in that unique military system. Of the Supreme Court not being to review either at all or only for clear constitutional violations, those decisions. There's no tradition, there's no history, there's nothing special or unique about this process.
I do think there is.
In the way that military.
I think there are different things that are special and unique about this process. And I think some of them are about the weighty constitutional concerns that Congress was obliged or at least allowed to consider in setting up a mechanism for something, as you were discussing earlier, in between a high crime and a misdemeanor and good behavior, for the judiciary to have some internal tools to manage judicial proceedings in a way that takes account of the public interest. And Congress,
They can do
after
that, but that's not inconsistent with then providing for judicial review of all constitutional claims, unless the outcome of this is that Article III judges just don't have constitutional rights that everyone else does if they're upon their removal.
Your
from
Honor,
office.
these all sound like essentially reasons that McBride was wrongly decided, not reasons that McBride doesn't apply here. Now, I think that McBride does a good job explaining why in this context, Congress was allowed to make the choices it did.
Well, what McBride said, the conference can decide the as-applied challenges. And if we look at the conference decision here and think that they didn't address the as-applied challenges, did not deal with the repeated and extended nature of this debarment from acting as a judge, didn't deal with the due process issues of having fellow judges, fact witnesses, people who have relationships with you as your adjudicators. What do we do?
Exactly what this court did in McBride and dismissed the as-applied challenges. Again, McBride did not say, we will consider as-applied challenges if the judicial conference is not going to. McBride said the opposite. We will not consider these as-applied challenges, even though the judicial conference at that
I
point
think they were sort of
refused.
thrown out on the assumption that the judicial conference then might change its approach.
Which it did, Your Honor. And I
But
don't
you
think,
can't point me to anything that says it does, other than you found one case where they said something about the Fourth Amendment, but they haven't done it in this case.
I disagree, Your Honor.
Okay, if we read it as that they have not addressed those claims in this case.
Then we would still be on all fours with McBride. I do want to, there was
I
something.
know, I'm telling you that if I read McBride as saying sort of a going forward, this is how as applied claims can be dealt with. And then it turns out they're not being dealt with. So that was not the world in which McBride was like, they don't seem to so now, but we're telling them that's where it should be. Let's see what happens. Right? They were not at this where they have looked at these claims and refused to decide them. So we are not in the McBride box in that context. I'm asking you what we're supposed to do.
I think you
If
just.
anything?
I think you dismissed the as-applied claims as McBride did. I don't think there's any suggestion, opinion that they're holding it open or
Then
retaining
we are
jurisdiction.
creating a statutory scheme here in which a body constitutional claims, and if there are ones that we were to conclude would be plausible ones here, are not to be heard at all. Are we not engaging in unconstitutional conduct or reading the statutory scheme to create a constitutional problem?
I think we are circling back to my profound disagreement with the assumption built in there that the judicial conference is refusing to engage in as-applied constitutional challenges.
I understand. I'm asking the question if on the assumption, so you'll have to take it on the assumption. I understand your position is different, that those claims, at least two of those claims, maybe more, were not decided or addressed in this case. Can't find it in their decision. Then what do we do? It's a very weird posture. I don't know what we do.
I don't think anything about the dilemma that would be of this court's own creation would change the plain meaning of Section 357C and what this court in McBride held it to mean. I do want to return to something in your earlier question about something about fact witnesses. Part of the rejection of the claims Judge Newman brought about transfer in the committee decision reflects the limited nature of the transfer denial that the Judicial Council has undertaken so far. The only matter it has declined to transfer is a misconduct proceeding that Judge Newman's counsel himself agreed did not require any witnesses and could be conducted on a, quote, paper record. For that
If-
narrow,
If you had a situation, say it's a Toomey versus Ohio situation, or not Toomey, that's too easy, but if you have something where judges are in fact witnesses or have personal experiential views and interactions with somebody, that would, in an ordinary court case, mandate recusal, is it okay for them to decide a pure legal question?
I don't know, Your Honor, and the Judicial Council
No, you don't
has,
let them. They're off the case. Full stop. There's no asterisk recusal. You don't come in to decide summary judgment, but not decide, but you can't sit on the trial because you've got information about the case, you've got a personal relationship. I mean, what's troubling here is the council's decision about why not to transfer is very much tied up to with their own information about why we don't want to transfer. We have the information. We're here, we're experiencing it, we're hearing these things. And so therefore, would be less efficient to transfer it to someone else. They do not divorce the very facts that are the groundwork for the concerns about fair process, or at least an appearance of the absence of fair process. They're interwoven in the very decision not to transfer, the misconduct decision.
and nor did Congress think, just like the Judicial Council, think that that type of background knowledge or access to the on-the-ground situation meant that circuits should transfer. There is no provision in the
That's
Act.
maybe a statutory answer. I'm asking
And
if
as
there's a constitutional question.
And what I am doing is highlighting Congress's view on this constitutional question. And while of course not binding on this court, I think Congress's views on this issue are at minimum entitled to some respect. And then I want to direct the court to
Where does
pages.
Congress have a view that says, keep it in-house when the judges, because the judges will have personal experience with this judge and personal knowledge of the relevant facts? Where did Congress make that judgment?
In sections 351 through 354 of the Act, which sets up a scheme in which judges of your home circuit decide these questions. The Act does not provide for transfer. Transfer is permitted by rule,
Mhm.
Rule 26, which provides that in extraordinary circumstances, that's when transfer is appropriate. And the Judicial Conference here, or its committee, endorsed the Judicial Council's lengthy and detailed reasons at page 40 to 50 of its September order not to transfer in part. And I do want to make sure that the court appreciates it's at the bottom of page 18 of the committee decision. It explains that with respect to the misconduct proceeding, the court had a situation of potential disability where there were ongoing effects on the functioning of this court, and that ready access to the committee was vitally important, both for ensuring that all relevant information was captured in the investigation and providing court staff who it is alleged were on the receiving end of some very troubling behavior, had confidence that they were being heard. Had
More
this court,
efficient to have judges who know the facts and themselves may be fact witnesses decide things, because that's more efficient than sending it off to a neutral arbiter who is objective about this and doesn't have personal knowledge or personal experience.
and shipping it
That's
off,
the answer.
and I think that was the Breyer report's answer too, is that there could be circumstances where transfer is appropriate. But the default is that you take care of this in-home, in part because the judges of the home circuit are closer to this problem, and in part because it's more.
Can you cite me another situation where judges who have, a council, a circuit council, has kept a case to sit in judgment on their colleagues? So not courts of appeals looking at district court, not district court looking at court of appeals, a colleague on their bench. And they kept it on the theory that we have personal knowledge of facts and we have had personal interactions. Is there a case like that? Because there's lots of examples in their briefs. I don't know the full body here of ones where courts say, no, district court judges say, I will not sit on a case of a fellow district court colleague. I will not sit on the case of someone who's in the same courthouse as me. Do you have an example?
I don't think they have a single example of a disability as opposed to a misconduct
I'm
case
asked- well,
being
this is a
transferred.
misconduct case.
It's true, but it started as a disability
Well,
case.
The whole, then
where-
you can't use the rationale that this was just a narrow decision about misconduct.
The disability inquiry remains in the background. It has been ground to a halt.
Okay, but then that,
By the
but then
refusal.
the problem there is if the disability one is where they really claim we have personal knowledge, we have personal experience, we
And-
have personal interactions.
And that has
And so
not been,
that's not divorced from
that
this.
has not been resolved yet. And both the
No,
council.
but that, sorry, you can't say it hasn't been resolved, but then say we get to use that information that might prevent us from adjudicating the disability claim, but we can bring that into deciding the misconduct claim because it's related to that disability claim.
Your Honor, at the time the transfer request was made on April 21, the council and the committee had before it both an ongoing disability investigation and a newly opened misconduct inquiry. And the investigation it was undertaking was relevant to both. I think there are very good reasons that a disability case where there is the potential for ongoing behavior instead of a discrete past act of misconduct to affect the very courthouse you're in, there are very good prudential reasons to keep it. And certainly that this did not rise to the level of extraordinary circumstances of transfer. Now, if we ever are able to restart the disability inquiry, the council has left open, and of course, Judge Newman would be permitted under the rules to call as witnesses fellow judges. At that point, of course, the council may choose to transfer, or if it didn't, the conference might choose to reverse that decision. But we are not
I
at that
understand
point
you're
yet.
not there, but then you just talked about, and I referenced as well, the fact that in their misconduct ruling itself, they pointed to matters of personal factual knowledge that they have as judges that informed that misconduct decision. That's why this misconduct mattered so much, right? It's preventing us from, we have these serious concerns about disability, and they recite, the order goes at great length, spends a lot of pages discussing these factual assertions about disability. And then they go, but this has nothing to do with disability. We're just deciding this isolated misconduct question. It doesn't hold up.
Your Honor,
It sounds like their personal information was affecting their decision on misconduct, or certainly on the remedy chosen to address this misconduct. Don't let her do any work. That addresses both an interest, like interim relief on our disability concerns, and addresses this misconduct.
I disagree that there was personal knowledge or personal witness testimonies by judges underlying either the order to undergo neurological screening or the misconduct finding when Judge Newman invoked her right under Rule 4A5 to claim she did not need to comply with that order because she had, quote, good cause to resist it.
They
Because
didn't just decide, did she engage in misconduct or not? They then picked a remedy. They picked a remedy of an open-ended suspension. It'll just keep getting renewed. And even if she complies, they don't say, once you comply, you'll be back on the roll. They said, well, if you comply, then we'll consider whether we should moderate this or not. There is no time certain. The only time certain thing is if you comply, then you can come back and then we'll think about it again.
Your Honor, I disagree that this order lacks a time certain. It is for 1 year. It is subject to renewal, but it is certainly not automatic.
It has a time within a time. The time there is within it is if you comply, you come back and then we will think about it.
That is true, but it also had an end date of 1 year. And so in advance of that 1 year, the committee did not automatically recommend
And it was
renewal.
renewed for the exact same
It
reason
was.
of, right. And is
After
there any reason
Judge-
to think that absent, is there any reason to think, given the nature of the decision that was made here, that absent compliance, it will not continue to be extended?
I think potentially, yes, that there may be a form of compliance that the committee is considering right now. Judge Garcia asked for an update. Instead of seeking judicial conference review of the renewed suspension in September 2024, Judge Newman chose to file a motion for reconsideration. And contrary to her earlier refusal to provide much medical testing, she has submitted a new set of CT scans that she asserts conclusively prove that she does not suffer from a cognitive impairment. I think that the committee's most recently released report shows just how carefully and thoroughly it is considering that evidence, even though it is not the type of evidence that the court requested. The court requested the standard neurological screening that's used to determine cognitive impairment. Judge Newman has now come forward with an alternate form of evidence. The committee retained 3 experts who have examined this evidence. They have surfaced many questions about it, and if the court wanted to go into closed session, I would be happy to update the court on further developments since that report was released in February. But even what's on the public docket exists, I think shows that just as a factual matter, we are not at an impasse, that the committee's mind, the council's mind is not closed. It's trying very hard to figure out a way forward here, and that there is no reason to sit here today and to predict the type of, quote, ad infinitum suspensions that the Judicial Conference refused properly to read this as. And circling back to where we started, if the court thought there was some sort of as-applied constitutional problem here, the Judicial Conference would be the appropriate body to address that. Now, if the court thought it can address these as-applied challenges itself, we think it should simply reject them, largely for the same reasons we think the Judicial Conference already has. I'm happy to answer further questions if the court has them.
All right. Thank you very much, Councilor.
Thank you.
Mr. Dolan, we will give you 3 minutes for rebuttal.
Thank you, Judge Millett, and I'll try to be as succinct as I can be. Let me just touch on the transfer issue. With respect to my learned colleague on the other side, I think the timeline is just incorrect. And as well as it's also incorrect that the transfer was denied only with respect to the misconduct. Transfer was denied when the disability issue was still pending, when it was not resolved. It was denied. The very first letter that Judge Newman's counsel sent to the Judicial Council was requested transfer. This is long before the Judicial Council said, like, look, we're just going to put disability aside and just do this on a paper record. And they denied it, and they said, we might reconsider it if you submit to the medical testing and you submit medical evidence, but we might not reconsider it. So I think that's just incorrect. Also, to the point that, can we restart this process? Is it all because of Judge Newman's recalcitrance? We can restart this process on disability today. And Judge Newman has asked on multiple times that she will submit to whatever test if it was ultimately going to be decided by neutral adjudicators. And as to your question, Judge Millett,
Wait, I didn't hear your last sentence. You said she will submit to whatever test.
that is ordered by a neutral counsel if it were transferred. Also, my colleague suggested that if the process gets restarted, she'll be able to call fellow judges as witnesses. That is just incorrect. In their September 2023 order, the Judicial Council said we would actually preclude her from doing that because we would decide if she wants to call all of us as witnesses, it would probably be cumulative, unnecessary, and this would be just a transparent attempt to sandbag us and to make sure that we can't adjudicate it. They
Where did they
explicitly
say
said
that?
that. That is, I don't have the page unfortunately in front of me, but that's the first suspension order. That's September 2023.
Of the committee or of the?
I think it was said in both. So I can provide the site, but it was done both by the committee and by the council. And finally, as my time is running short, I want to address McBride a bit. McBride itself necessarily, footnote 5, necessarily contemplates at least some as applied challenges because McBride leaves open the possibility to consider whether long-term suspension essentially affect her removal. That is necessarily an applied challenge because you have to wait what kind of suspension is visited upon a judge to see is it long enough, to see is it global enough before addressing it.
Well, you're talking about footnote 5?
Correct.
It says we do not decide whether that would, by its practical effect, constitute an unconstitutional removal. I mean, one way of understanding that is they've just said we don't consider as applied challenges. So obviously, we wouldn't consider that as applied challenge. Why is that not?
No, I don't think that's the best way to read it. I think the court says that because by the time McBride came up, that his suspension already ran, and the only thing that was left on the record is really reprimand. And the court said that, look, we're not considering this applied challenge, but we do not decide this specific question, which also recognizes that some suspensions could affect removal, which would not only run afoul of the Constitution, but would run
I
afoul
want
of
to
this
be clear
statute.
about this, right?
Yeah.
In the government's view, our opinion should have that exact same footnote. It would say that's the as-applied challenge. We also do not decide whether a long-term removal.
I guess so, except that this
Because it
is,
says quite clearly in a lengthy section, many pages earlier, that as-applied challenges.
but I think they reserved that as applied. I think that's the import. Otherwise, this footnote does not work. And of course, we're now in that situation. And in
It
the
does
last,
work, it flags a problem, a potential as-applied challenge for the judicial conference.
no, I think they would, then the footnote would read differently. It said that, look, this is a problem, and maybe Congress ought to address it, and maybe Judicial Conference ought to address it. I think the best reading of it, that we're putting that issue to the side because this is not what happened to Judge McBride. And if you allow me just a couple more seconds, Judge Millett, just to address two more points, an important one, also about McBride. The problem is with McBride is that post-McBride, Supreme Court decided Axon, and where it explicitly said that administrative bodies, which Judicial Conference is, and they said it in their opinion, just in this case, not just before, in this case, that this is administrative proceedings. Administrative bodies, no matter who they're staffed by, whether they're staffed by Article 3 judges or ALJs or whatever, they do not have the power, do not have the constitutional power to hear and adjudicate constitutional challenges, whether on its face or as applied. So whether you look at footnote 5 or whether you look at, is McBride even good law?
That is not what Axon said. Axon said an upfront facial challenge to the power of a body, its legal capacity, whether it's even a lawfully constituted body. There they had appointment and removal questions
Right.
to adjudicate that type of claim. Your argument that this body can't decide anything about me because it is illegally and unconstitutionally constituted allows me to get out of exhaustion requirements and go to district court. That's what they said.
Well, no, I think Axon and
Didn't say
rely,
anything more than that.
I think there's a good line of Supreme Court precedent that says that administrative bodies simply cannot
Okay,
adjudicate.
is either the conference or the circuit council, are they executive branch agencies?
No.
Or there's Article 3 agencies?
The Article 3 agencies,
Nothing
but
else
they're
applies
not,
to Article 3 agencies.
no, but they're not courts. So the mere fact they're staffed by Article 3 judges does not make them courts. So Article 3.
understand that,
right.
I'm just saying
So
that-
they're still agencies. So I don't think, in that sense, I don't think it matters.
Okay.
And the last point is the perception of bias, Judge Millett. You're exactly right that there is, whether real bias or perception of bias, that you have before you the brief by the DC bar that says that one of the reasons the facts are, not that the court needs to delve into them, but one of the reasons the facts are presented to the DC, to the federal circuit are so one-sided is because some of the attorneys who've litigated in front of Judge Newman, who appear before her, are not comfortable speaking up in her defense precisely because of this nature, which in turn makes this case extraordinary.
Any other questions?
That's the first question. Thank you very much.
Thank you very much to both counsel. The case is submitted.
Honorable Court stands adjourned until Thursday, May 1st.